We're joined on the line by legal expert Mpumelelo Zikalala. A very good evening to you, and thank you so much for speaking to us.
Good evening to you, Nessa. Good evening to your viewers and listeners.
Let's just first start by understanding what are the legal doctrines that govern digital media information in South Africa for evidence.
It basically says anything that emanates from you that can be proved that it comes from you and it has been broadcasted to other individuals can then be used in a court of law for various other things. Obviously, the basic legal elements will need to be approved to say this is a post that comes from Zikalala, this is it has been authenticated or it has been accepted by him. And then the second inquiry would be, what was the post about? Did it include any infringements which can be regarded as an infringement in law, for example, criminal injury, defamation, or any other infringements that can be there? Obviously, the production of legal of experts in terms of your tech experts that will come in and prove in court that indeed this is a post that comes from me is something which is considered. Then there's then a very important piece of legislation that says any publication that comes from you, it's as if you are the one who's broadcasting it and you're going to be liable for it. So the law has developed in a very quick way when it comes to electronic communication, in which there is even legislation that caters for that. So, which is why you must be very careful when you are broadcasting things. It's as if you're talking to another human being. It's as if you're talking to a crowd, especially when it comes to social media, where one post can reach over 500 individuals in a matter of minutes.
Just in terms of, you've just outlined the legal thresholds, but admissible versus probative. How does one know what could put them in danger, especially in personal injury cases like we're talking about, and your knowledge of what could be seen as evidence?
Well, you must look at it in this sense. Whatever that you are going to assert, especially in a court of law under oath, must be something which is truthful. So if you say, I have this injury that is there, but you can see you on social media post doing exercises in which a person with that injury will not be able to do so, it does cast a bit of doubt. Obviously, there'll be added other information which would need to come in order to pass the master that has been put in when it comes to the level of proof when it comes to this type of cases. But the mere existence of your social media post proving the probable value that you are not injured as much as have been injured is something that can be taken by the court. So it's important to realize that whatever that you broadcast in the media or broadcast in the eyes of the public can be used at some stage against you, can be used at some stage in which will then be called upon to explain exactly what was happening in that particular post. But it doesn't go alone. There's some type of supporting evidence, especially from an expert, that will need to be coupled with it so that when you go to court, it has a bit of weight with regards to it being considered as evidence.
And that's what I'm also just wondering in terms of the jurisprudence in South Africa in regards to social media content and the privacy law. How is that balance achieved?
Well, the balance is achieved in the following manner. Your right to privacy is as much as you want us to sort of intrude it. So if you're going to post something in a public manner, you are basically saying, I'm waiving my right to privacy and allowing you as members of the public to look into what I'm posting, to comment on it, to share it with other individuals. So you can't say this is a private post, it's not supposed to be shared by anyone. We are the one that has opened the door in terms of that private post being shared into various other things. So the manner in which they're going to interpret what you have stated, how it's going to sound like to other individuals, is something that would be viewed at a later stage. But when it comes to privacy, your right to privacy is there. Yes, it's a general rule. However, the exception to the rule is that if you then open the door for scrutiny to happen on a private matter, then you can't come back and plead that this is a private matter, shouldn't be shared by anybody else.
And then there's the legal paradox of deleting devices. Might that be misconstrued as an attempt to delete evidence? If, for instance, I'm moving from one phone to the other and you will get a prompt that says, should all data be deleted from the old phone?
Remember that the data belongs to you, so you're privy to do whatever that you want to do with it. It may be detrimental if you're going to go into a legal battle at a later stage and you're going to need the data in order to prove that you are correct or you are right, or to prove that, for example, it was distorted in any manner. So the deleting of the data can save you, but it's not going to save you absolutely. You must remember that at the end of the day, whatever that you've posted is probably going to remain some out there in the internet for a couple of years. And the mere fact that you have deleted it from your device does not mean that it can't be accessed again. Remember that technology is also advanced. Whatever post that I post now can be saved by somebody else. And if they can be able to prove that it emanates from me, and there's some type of defamation or criminal injury that has taken place, they can take me to court. I always say this. In order to test whether what you are posting is something that can be useful for public consumption, ask yourself this question: would I be able to repeat what I've stated now to my mother, to my grandfather, to my grandma? And if the answer is yes, you're not going to feel any remorse, you're not going to be ashamed of anything, then it's a good post. But if there are reservations of any sort, especially when you touch on things like religion, touch on things like your gender, and all the other sensitive issues in which currently we're dealing with the world, be very careful in what you post, because it may come back to bite you.
Now, there's also the rise of deep fake and digital impersonation. Is that ever taken into account?
Yes, it is. When it comes to the defense in which you'll provide in court. So basically, we then say, because I'm not an expert when it comes to tech, I have taken my device to a tech expert. They have been able to trace my logging in details within the social media avenues. They are able to provide the time in which I've logged on and what I've stated. Look at the post in which we're interrogating. Probably it is fake. We don't even know where it emanates from. So it can't be me that posted these mean stuff and things which are sort of offensive when it comes to the way in which they're perceived by members of the public. So,
yes, sorry, conclude that train of thought.
Yeah. So that's the type of evidence which we need to produce. Quite expensive, by the way, big time consuming, but because you want to protect your integrity and your dignity, unfortunately, you'll have to go through the process.
And just a final question: what about posts in which friends tag you? For instance, I've heard of an incident where somebody was claiming this was car insurance, and the insurer had looked at their bank statements and seen that they'd bought alcohol, say, days before. But that does not necessarily mean on the day they were drinking. But I'm thinking in a situation like this, what if a friend tags you they're drinking, but it makes it seem like you're drinking, but you're not necessarily doing so? So how do you protect yourself from such incidents?
With tagging is a bit different. If you've got the safety features that says if I've been tagged, allow me to give the permission to broadcast it, even the tagging of me on that particular account. There's one security feature that you can be able to use. But this is what you must always remember. Anything that you have been tagged on that you publish, it's as if you are the author. So if there's initial damage or certain information that was projected earlier, in which you have simply pressed the shared button, it's as if you are the author. All the other illegal implications which will then apply, it's going to apply to you. When it comes to insurance companies and the gathering of evidence, probably they're going to use your post, and indirectly you might have landed your friend in trouble by broadcasting and sending this information that is there. Remember, insurance companies are going to do everything in their powers to go and investigate, just to check whether you are telling the truth in terms of the sequence of events. Yes, they do realize that they pay for your negligence, but you must be truthful about it. So it can be utilized in a court of law. The rules of evidence, though, will still apply. Make sure that it is authentic. Make sure that you find someone that can be able to prove that it comes from you, and it can be used as evidence.
Chill just went down my spine. Thank you so much for speaking to us, legal expert of Zigalala Attorneys, Mpumelelo Zigalala, speaking to us about this. As we've mentioned, legal experts in South Africa are warning that social media usage, advising users that they should treat every post as if it could be read in court, so it could be used as evidence against you. And as you heard him say, if it can be traced back to you, and if it tracks with what the insurance company are trying to prove.